and the Institute of Mediators and Conciliators. He's also a CEDR accredited mediator. Godwin has over 25 years of active experience in domestic and international arbitration and mediation relating to a wide range of disputes in the oil and gas industry, construction industry, taxation, anti-bribery, and corruption. He has a stellar track record in arbitration, as well as other forms of alternative dispute resolution, which have been recognized by all major directories, including the Legal 500, Chambers Global, and IFLR 1000. Welcome, Godwin. Finally, we have Nikhil Desai, who is the managing director of J. Miles and Company, and is also the managing partner of Desai and Company Advocates. Nikhil is a fellow of the Chartered Institute of Arbitrators and is a renowned advocate of the High Court of Kenya, specializing in international arbitration, fraud, and asset recovery. Nikhil is the chair of the International Chamber of Commerce, ADR Commission in Kenya. He sits on the ICC Kenya Arbitrator Nominations Committee and is a member of the ICC ADR Commission. Nikhil is part of the team that was awarded the African Arbitration Awards Leading African Arbitration Service Provider Award for 2 consecutive years. He has represented both private clients and government entities in numerous local and international arbitrations under the auspice of ICSID, ICC, LCIA, FOSFA, UNICITRAL rules, and the Chartered Institute of Arbitrators. Nikhil has also sat as arbitrator and tribunal secretary in local and international arbitration. Welcome, Nikhil. So to kick off today's discussion, we would like it to be as interactive as possible. And I think the first question that we would like the panelists to engage with is, how has the landscape of investment arbitration in Africa evolved over the past decade? And what are some of the trends you have seen within the investment arbitration in Africa? Perhaps we can start with you, Professor Mutuma.
Thank you very much to our esteemed moderator. Let me confirm first that I'm audible before I speak for very much. There's a time I was online for about an hour only to hear it, to get the feedback that no one was hearing what I was saying. Madam Moderator, you can hear me? Okay, fantastic.
Yes, you can hear me very clearly.
All right, okay. Okay, so I'm very, very glad to be a part of this panel. Thank you very much for organizing it. C.Arb, I'm also very, very, very thankful to be with good friends of mine who we collaborate in different avenues, channels, and they will bring a rich experience in terms of the topic of our discussion today. Very thankful also to be with the delegates that have joined us. And I want to pick up quite quickly from your question, Madam Moderator, on the evolving landscape. I think there are 3 areas that I'd like to simply point out. One is that more and more Africa has become integrated in the global economy. So that is a major, major difference from the post-independence infrastructure that existed. We find increasingly there is more and more investment, not just from the West, our traditional investment partners, but also from the East. So the story of Chinese investments across Africa is a big one. Second, I think, is the geopolitical context in which all of this is happening. Before, of course, we had a unipolar economic paradigm. More and more, I think we're seeing a multipolar paradigm. There are tensions across the East and West, which are presenting certain opportunities for Africa as an investment destination, and specifically as a neutral dispute resolution forum. Third, of course, is the perspective around arbitration, questions of fairness, and what needs to be done in that area. So the history, of course, is from a very pro-investment posture, where Africa at very early stages, post the independence period, was trying to attract investment to where we are now, where there is greater sensitivity around the nature of those investments and the extent that they are a reflection of fairness, both procedurally, in question of the seat, and also both in terms of the outcome of those disputes as they happen. And then, of course, for us in this particular region, there's been a lot of activity when it comes to trying to profile Nairobi as a credible arbitration venue. So it's not just here in Nairobi, but I think it's quite across in different centers of the African continent, the activity around the establishment of arbitration centers, and the activities around building capacity, and the activities around dealing with perspectives of the suitability of Africa as an investment destination. I think those would be my opening remarks, but the conversation will get, I'm sure, at a certain point quite heated up as we peer through the lenses on what this means for us as practitioners and what it means for our jurisdiction. Thank you very much.
Thank you so much, Professor Mutuma. I think that was a great start, and I think we would just like to have Godwin's contribution on the same topic as we kick off.
Thank you, Madam Moderator. It's good to see you again and to see my brother and my very good friend, Professor Wayne Mutuma. Prof, good to see you and good afternoon to everyone. Thank you.
Delighted.
Yeah, it's great to be part of this conversation, which is ongoing at the moment. I think some of the points I wanted to make, Wayne has touched on them, but I will just for emphasis reiterate a couple of them and try to expand a bit more on them. The landscape of investment arbitration in Africa have undergone a significant transformation over the past decade, moving towards greater regional control and a rebalancing of investor rights. This evolution is driven by a combination of factors, including a growing critique of traditional investor-state dispute settlement, the rise of African-centric arbitration institutions, or if I want to use the cliche that is being used now, the Africanization of dispute resolution through regional institutions and dispute resolution clauses. And of course, the push for a more harmonized legal framework under initiatives such as the African Continental Free Trade area. An interesting statistic I would want to refer to is that according to the 2024 OCTAD report, as of 2024, out of nearly 3,300 international investment agreements, over 1,000 of such investment agreement treaties involved African state parties. And as far as I can see it from where I stand, I think the key drivers that have shaped the investment arbitration landscape in Africa include the following. Professor Wayne has mentioned a few of them. Increased investment and dispute. The past decade has seen a significant increase in international trade and investment on the continent. Of course, as a corresponding consequence, we are seeing a rise in cross-border investment disputes. The Africanization of investment laws in Africa as well by African states. They're becoming more active participants and they're increasingly shaping investment law and arbitration to be more equitable and focused on their interests. We're seeing a diversification of investment instruments. For instance, as a direct response to the criticisms against the ISDS system, there have been deliberate creative efforts at reforming BITs and regional investment treaties. For instance, the 2016 Morocco-Nigeria BIT, the Hungary-Cape Verde BIT of 2019, both of which innovatively preserved the right of the various states to regulate in the public interest, to promote sustainable development, also made provisions for corporate social governance and the protection of the environment. And now, this new generation BITs, because that's what they are often called now, constitute a significant departure from old generation BITs, which accorded investors more protection. Other African states, such as South Africa, for instance, have chosen a different route to investment arbitration. South Africa has terminated many of its BITs and have enacted the Protection of Investment Act 2015, through which investment disputes are resolved via mediation or through the national courts. African states have moved away from the perceptively skewed first generation BITs to more balanced generation of BITs. We are also seeing as a key driver the rise of resource nationalism and a shift in policy. Many African states have become increasingly critical of the traditional IDS system, viewing it as disproportionately favoring investors and encroaching on national sovereignty. This has led to a noticeable trend of states, particularly those with valuable natural resources, renegotiating, terminating, or choosing not to renew older BITs. And this shift aligns with a broader policy of resource nationalism, where the African states are seeking to control more of their resources for the benefit of sustainable developmental purposes, right? We're also seeing again a growth of regional arbitration institutions on the continent. There has been a clear move to localized dispute resolution. African countries are developing and strengthening their own arbitration centers to handle international disputes. The goal is to reduce reliance on foreign institutions like the ICSID, the ICC, which have historically handled the majority of cases involving African states. We are also seeing that more African arbitration seats and better domestic frameworks are emerging on the continent. African seats, for instance, such as Mauritius, Johannesburg, Cairo in parts, and local arbitration laws have been modernized, and courts in some jurisdictions are showing greater support for the arbitration process in terms of enforcing international arbitration awards, improving the attractiveness of Africa as a place to invest and to seek arbitration. And the whole idea that once Africa is more attractive, then of course the need for some of this investments, foreign investors scheme will be obviated. The impact of the AFCTA, it's really going to be a game changer. Its protocol on investment introduced a new framework for resolving disputes that moves away from conventional ISDS. The protocol emphasizes mediation as the primary dispute resolution mechanism and encourages the use of African arbitration institutions. And that's why it's important that we continue to strengthen African arbitral institutions. The protocol is also a major step towards creating a uniform system for investment and dispute resolution across the continent, which could significantly alter how disputes are handled in the future. The investment protocol intends to harmonize intra-African rules and to replace many intra-African BITs, signaling a move to a more regional, state-centric framework for investment and dispute prevention / resolution. I think while significant progress has been made, challenges remain. Issues like the inconsistent enforcement of arbitral awards in some jurisdictions, concerns about the impartiality of some domestic courts, and the high cost of arbitration still need to be addressed. However, the overall trend points towards the future, in my view, where Africa is not just a participant in investment arbitration, but it's also an active shaper of its own dispute resolution landscape, with a focus on regional solutions and a more balanced approach to investor and state rights. So those will be my opening remark, Madam Wambui, on the trends, the way they have evolved over the past 10 years.
Thank you so much, Godwin, for those insights. And I think you touched on some crucial points, including unfavorable BITs, the control of resources in Africa, and the potential impact of AFTA if and when it is enforced potentially. But before we delve into some of those issues in a more detailed manner, perhaps we can get Nikhil's views on the impact over the last decade, and then we can circle back to some of those finer details. Nikhil?
Hi, thank you, Madam Moderator Wambui. How are you? Thank you very much for the opportunity to speak. I'm not sure my video is on. Can you see me?
Yes, we can see you and hear you clearly, Nikhil.
Okay, great. Thank you. So thank you for the opportunity for being invited to speak in this panel. In addition, just want to thank my fellow panelists, Chairman Mutuma and Mr. Omoaka-san. It's a pleasure to be here. I think as an introduction, my co-panelists have covered quite a bit of what I was going to delve into. But perhaps what I would touch on is just, well, the developments over the past, say, last decade in investment arbitration. I would divide them perhaps in two areas. One would be the investment treaty arbitration, which my co-panelists talked about, BITs and MITs. And just the background of that being that they were all entered into at a time really where Africa was trying to attract investment. So the BITs were negotiated at a time where it was by and large one-sided, and there is a need to modernize that. And hopefully we'll delve into that in a bit more detail. But more importantly, if you see the trends in the last 5 years in terms of the BITs that African states have been entering into, they're more focused as opposed to how they were in the past, being West, Europe and Africa. They're more focused on South-South BITs and intra-Africa BITs. Mr. Omoaka talked about the Morocco and Nigeria BIT, which is a very good example. But you're now seeing a number of BITs with Arab states, and that just goes to show the increased investments, not from one part of the world, but a larger part of the world with a bit more fair bargaining power than we perhaps had at the time of the old generation BITs. But what the reaction really has been with the, at present, there are no modern BITs as we would classify them, I think, with African states and the West. However, that's largely because of the sunset clauses in the old generation BITs, which meant that they continue taking effect for, in some instances, over 20 years. But as Mr. Omoaka mentioned, South Africa took some call it drastic action, others say it was in the interest of South Africa. They took an action in around 2012 to withdraw from a number of BITs. And the reason really was it arose from a claim with pursuant to a BIT between South Africa and Luxembourg, whereby South Africans' mining laws, which were meant to implement the Black economic empowerment national policy, whereby those who had historically been marginalized were given interest in some national resources, would have a stake in the mining rights. And as a result of that case, which eventually ended up settling, the South African government really felt that these BITs hinder African states from implementing national policies. They're not transparent. And this has been proven by precedents in investment arbitrations that there is no clear precedent with regard to how certain clauses in BITs will then be interpreted. So there's no set norm with which a state can start implementing national policies when there is no uniform precedent in that area. So that, of course, what we're trying to resolve is getting into model BITs which have more clear provisions in that regard. But just moving away from the treaty-based arbitrations, if we're looking at the contractual-based investor-state arbitrations, I think all the lawyers over here who've dealt with international investment arbitration will agree that we're seeing a shift in arbitrations being in contracts, being required to be seated outside of Africa. We've seen a number of investment arbitrations take place on the continent, which is a big development, largely because the African legal community has been very proactive for the last decade in promoting international arbitration, ensuring a conducive environment for the same in Africa. So I think that's definitely a positive a step. There is still quite a bit of work needed to get African arbitrators to sit on these investment arbitrations, but steps are being taken, and I hope we can discuss that further during the chat. So I think I'll start off with those few remarks. Thank you.
Thank you so much, Nikhil. And I think I just want to piggyback off of the sentiments you've made with respect to the BIT. Delving further into that topic, how are African states redesigning BITs to balance their investor protections with the suitability and governance priorities that they currently have? I think another angle with which we can discuss that is what were the old BITs touching on that were so detrimental to the African nations, including the negotiating capacities? And what do you see as the future of similar agreements, investor-state agreements today? Maybe we can kick off with you, Nikhil, because you're already on a roll on that one. So you can just continue on.
Sure. So perhaps we can put it in perspective. If we're looking at most BITs having ICSID as the dispute resolution mechanism, we have, I believe, 50 African states who've signed the ICSID convention. 3 are yet to ratify the same. And from those, almost 80% of BITs by African states are old generation BITs. So just to put it on context, and the average claim from a BIT dispute is around $1.1 billion US. So a figure that would actually affect a developing country. But if I was to just give you certain examples, perhaps using one from home, a number of people must have read the Quartec Republic of Kenya ICSID decision, which was recently given. And that was a BIT between the UK and Kenya, I believe. And the definition of investment there was a standard clause definition, but it missed out one very crucial element, that the investment had to be in accordance with the laws of the host state, in this case, the laws of Kenya. In that particular claim, the issues were to do with how the license was procured and environmental impact assessment, while the tribunal, in that case, while it was not bound to say that the investment was not carried out in accordance to Kenyan law, took the initiative to read in that the investment needs to be legal in nature. So that just gives you an example of how the clauses in old generation BITs are drafted. And if you're missing certain key provisions, it could actually lead to detrimental effects. Another, perhaps if I can give you one more example, which has come under a lot of scrutiny, and that is the fair and equitable treatment provisions in BITs. Now, in the old generation BITs, the wording is slightly different, but more often than not, it simply states that the investor will be given free, fair and equitable treatment in the host country. Now, that has been interpreted in a number of ways by tribunals, and there's no set criteria which a host country can consider when, for example, it's planning to implement a national policy. So that has led to a number of conflicting decisions. And what the model BITs are trying to do is limit, either take out the fair and equitable treatment because it's too broad, or to limit and further expand on what those fair and equitable treatment provisions entail, so that you're actually working within a set criteria as opposed to leaving too much discretion to a tribunal. So that's just perhaps one of the examples. The new generation BITs also put in very key provisions with regard to the investors' obligations to, for example, ensure investments are sustainable. They're taking into account corporate social governance issues, climate change issues. And to put that into perspective, a lot of African states have recently already have in place a number of international conventions on climate change, right? Now, if there is an old generation BIT in place and an African state is trying to amend its domestic laws to conform to those international conventions, bearing in mind that if they don't do that by a certain time, then there would be implications under the climate conventions as well to the host state. It's very difficult for the governments to actually ascertain whether implementing those domestic policies would be infringing on BITs, just because of the way they're currently crafted and precedent on the matter. So the model BITs are really to put more of a defined scope on what the protections are, in addition to putting obligations on the investors as well, as opposed to it being one-sided.
Thank you so much, Nikhil. Godwin, is the perspective any different in Nigeria? And what are your thoughts on the old generation BITs and the potential of getting into similar or amended or new BITs between African states and in potential investors?
Can you hear me?
Yes, we can hear you.
Okay. Yeah, thank you. I think Nikhil has done a great job of setting the context and explaining the issues. I think it all stems from the old generation BITs, the historical perspective, when African countries were looking for investments into the continent, and then they find what we call the old generation BITs. But gradually, there have been a shift, a proactive shift, conscious shift by African states to move away from that old generation BITs. And what we have seen over the past decade, and which Nikhil mentioned, if a renegotiation, a termination, or a complete reformation of the entire BIT system to new generation BITs. And one of the striking things is that the current BITs, in addition to pursuing sustainable development goals by ensuring that they are, the African state is able to regulate in the interest of the public. They introduce corporate social responsibilities, environmental protection issues, health and safety issues, human rights law, and all of that. I think one striking provision for me is the fact that currently obligations have been imposed on the investor as well, right, in those regards, so that in the event of a breach, then the African states are able to counterclaim against the investor in relation to the modern BITs as we see them. So that is what is gradually happening, and I think that is commendable, because even in Nigeria, other than the Morocco Nigerian BIT of 2016, Nigeria have been very cautious to sign new BITs. It haven't entered into any new BITs since then. Even the Morocco Nigerian BIT that we keep talking about, interestingly, haven't even come into force. It has been signed, but it hasn't even come into force, right, ratified by the Nigerian parliament. So there is some cautious optimism by government about the whole ISDS system. And we continue to see that, in the coming together of African states under the banner of the African Continental Free Trade Agreement and the investment protocol, which is, aimed at providing a more robust, more African-friendly investment climate and dispute resolution mechanism for African states. Just to give you a sense of some of the triggers as to why African states have actually scampered away from the old generation BITs. And this is based on some exit statistics. As of December 2024, there are at least 171 pending ISDS cases across African states. A notable concentration of these exists in Egypt, 46 cases against Egypt, Libya, 22, Algeria, 13, together amounting for nearly half of this. So imagine a country like Egypt having 46 ISDS cases against it. It needs money to develop. It's a developing country. And when you begin to have awards against them from these sort of claims, it tells you how that is going to impact the development of that country. We see something similar playing out in Europe with Spain under the ECT Charter, when Spain tried to push for renewable energy, regulate the renewables energy sector. And Spain was inundated with claims by investors. Over 40 ISDS claims were brought against Spain. In fact, only last week, I think there was an enforcement in an Australian court against Spain. So those sort of numbers tells you why African states are taking the pause on investment arbitration, and why they are increasingly beginning to look for other ways of either they're terminating, they're reforming, or they're just entirely moving away from the current BITs as we know them, which are the old generation BITs?
Thank you so much, Godwin, for your perspective. And Dr. Mutuma, just building up on the conversation that we are having, there are views that the approach taken by South Africa to completely withdraw from the BIT was slightly drastic. What are your thoughts on how Africans can bring investors back to the negotiating tables to have conversations about potentially new investments agreements or new BITs, noting the geopolitical arguments that you had already raised? What is the likelihood of bringing a fair document to the table and having that executed? Or what are the alternate options to African nations if the old BITs don't serve them? What can they do? Professor Mutuma, have we lost you?
Wambui, it seems that Prof has been logged off. Maybe we can continue as we get him to log back in.
Okay, sure, no problem. Thank you. Perhaps we can move into what sectors of investment arbitration are most impacted in Africa. And in your own view, Nikhil, perhaps, is it that some of these investors are coming to the African nation and not performing their contracts? What is the basis of the investment arbitration proceedings and the key trends that you've noted in some of the disputes that have been arising so far?
Thank you, Madam Moderator. Perhaps I'll just follow on from what we were talking about South Africa to give further perspective. In addition to South Africa pulling out of certain BITs, Tanzania in around 2018 implemented two laws, which is the new Public-Private Partnership Act and the Permanent Sovereignty Act. And in those acts, they said that any disputes relating to natural resources or public procurement could not be subject to international arbitration. Now, at the time, just given the resources that Tanzania had, there were a number of foreign investors who had already invested a lot of capital in those industries who were concerned. And there was a lot of uproar as to what would be happening. And the reason that Tanzania was under pressure to implement those laws, in addition to the government of the day, was that they'd recently had a number of arbitration awards against the government through state entities, which resulted in the attachment of Air Tanzania flights in Canada and elsewhere. And that brought a lot of, obviously, the national symbol, and rightly so. There were concerns about the extent of the quantum of these arbitration awards. So that's just the background as to, eventually Tanzania had to correct that position. And I believe the new Arbitration Act of 2020 allows arbitrations relating to natural resources and PPPs, which are seated in Tanzania, though, right? So that had to be corrected. So obviously there is that balance to be struck in the sense that it's difficult to fully go away with these investment treaties or investment protections. But at the same time, there's a need to also push the African agenda in terms of control of the dispute resolution process, right? So definitely as a starter, it's very hard to go from one end to the other. There has to be a middle ground as we try and reach what Mr. Omoaka talked about as being the Africanization of investment arbitrations. But by and large, most of the disputes that we've seen arising in terms of investors has really been either direct expropriation or indirect expropriation, either through the implementations of legislations which require national ownerships of particular investments, or expropriations for public policy, which according to the investors had not followed the correct procedures. And the problems that have really arisen for the African states is the wording of the BITs. So if we're looking at the expropriation provisions, they do have these are the old generation BITs. They do have wording talking about expropriation being allowed in a sense if it's for public policy reasons, but nothing really further on that point. And what the new generation BITs try and do is allow governments to, take assets or natural resources when it's for public policy, and to follow a specific framework to ensure that there's compensation given to the investor for that expropriation. Now, that was what was lacking in the old generation BITs. Again, if we're looking at, for example, change in legislation resulting in indirect expropriation, again, if there is a legitimate public policy objective that our African state was trying to implement, there was no set procedures in the old generation BITs. So these are the things that are trying to be corrected in the model or new generation BITs.
Thank you, Nikhil. Godwin, you had touched on the after investment protocol, and I just wanted to get your thoughts on whether you think that would offer reprieve to some of the African nations in terms of the investments that are currently prevailing and the push towards amendments of some of these investment agreements.
Thank you, Madam Moderator. I think it would, and the reason is very simple to decipher. If you look at the after investment protocol, I think it's a landmark instrument, right? And it could significantly reshape the future of investment arbitration in Africa. Now, for decades, African investment have been fragmented, dominated by hundreds of bilateral investment treaties, many of them outdated, one-sided, and investor-friendly. What the protocol does is to make a clear shift toward a more balanced African-driven network. And I'll just perhaps try to highlight 4 of those first. What it does is it harmonizes investment rules across the continent. All right. So instead of a patchwork of inconsistent treaties, we now have the foundation of a common standard that provides predictability for investors, while at the same time safeguarding the legitimate interest of states. It's also the protocol also seeks to rebalance dispute settlement, unlike traditional ISDS, which often gives investors a direct and immediate path to arbitration. What you will find with the protocol is that it emphasizes the role of domestic remedies, talks about amicable resolution modes via consultation, negotiation, and then consider state-to-state dispute mechanisms, unlike the current system whereby an investor can straight up bring a claim against a host state under the current African protocol. What you will find is that the investor will have to go through diplomatic channels, which is the state, to be able to bring that claim. And it also narrows the scope for investor claims, like I mentioned earlier. African arbitration may also play a role, but it's important that as a mechanism of last resort rather than a first port of call. Third, it strengthens the policy space of African states. So what does that mean? By expressly protecting the right to regulate in such areas as health, the environment, and industrial development, the protocol reduces what we call the effect of regulatory chill, which is the fear of African states to regulate in the public interest, because they are feared that if they do so, an investor may be aggrieved and may then bring an investment treaty claim against them. I recall a similar situation in Nigeria happened a few years ago, where the Nigerian government had to regulate to introduce new incentives in the oil and gas industry. One of the major oil players in Nigeria Nigeria under the Nigerian Netherlands BIT at the exit, but eventually that claim was settled. I mean, wise counsel prevailed, and the claim was settled. So perhaps more significantly, is that the protocol also introduced investor obligations. For the first time at a continental scale, investors are expected to meet standards relating to environmental protection, labor rights, anti-corruption, and corporate governance. This reflects Africa's determinations to ally investment protection with sustainable development goals. So I think the protocol can help strengthen African arbitration institutions by encouraging disputes to be resolved on the continent. You can build capacity, it enhances trust in African centers, and gradually reduces dependency on foreign seats of arbitration. So these are some of the advantages that I see will come with the AfCFTA investment protocol once it's begin to be actively used in the African continent. Because again, what you will see is that it will encourage trade, intra-African trade, which is the whole idea behind the AfCFTA agreement itself, whereby because of the protocol, Africans are now able to undertake more trade with African states, and if there's an ensuing dispute, it is resolved through the investment protocol. So those, for me, I think are the key advantages at this time that the protocol provides over the existing ISDS system, which is basically dominated by the older generation or first generation BITs.
Thank you, Godwin. Two things. One, I think Professor Mutuma will be joining us once again shortly. But in the interim, for our online guests, please feel free to use the chat box below and ask as many questions as you would like clarification for, and we'll bring them up as and when we are having the discussion. Godwin, while I still have you, just building on something that you said, the protocol is highly dependent on the buy-in of all stakeholders, and it has been characterized as an Africanization document and an accountability document. Why is it important to Africanize arbitration, and what roles do you think institutions like NCIA, KIAC, MIAC, C.Arb can play in this Africanization?
Thank you, Wambui. I think Africanization is very important, even though I personally disagree with the phrase Africanization, all right? I just think it's a sort of cliche. But I think the idea is to have more arbitration seated in Africa. The idea is to have more Africans appointed as arbitrators, right? Not only in relation to African-related disputes, but to disputes from other parts of the world. And just to put it in context, let me share with you some statistics which I just found this morning, very troubling statistics from the investment from ICSID about how Africa has sort of been shortchanged in the investment arbitration framework, and why you begin to see the quest for Africanization, and then I'll come to the role that the institutions will play. So, for instance, you will find that in terms of arbitrator appointment, right, Africa have been grossly underrepresented. For instance, the listed ICSID statistics for financial year 2025 shows that only 5% of Africans have been appointed by ICSID as arbitrators for the year 2025, the year we are currently in. In 2025, the most appointment went to arbitrators from Western Europe with 39%, despite claims of cases from that region being only 9%. South America had 22% appointment with 18% of claims coming from South America. North America has 16% appointments with 7% of claims coming from North America. Africa, where you have African disputes from the African continent alone, according to the latest ICSID statistics, was about 24%, all right, from sub-Saharan Africa. If you add the MENA region, which is another 5%, and the MENA region in this case we have Tunisia, Morocco, and I think Algeria, right, which are actually African countries. If you add that together, it means that for year 2025 alone, we are seeing about Africa representing 30%, because actually 29% of all global disputes under the exit framework. Yet only 5% appointments have been appointed for the year 2025. And then historically, the exit statistic, which was just released last week, shows that historically, sub-Saharan appointments have just been about 2% of arbitrators, historically for over 50 years. Then, of course, there is a perception when it comes to the award that has been handed down by investment tribunals against African continents, African state parties. For instance, I think they say African parties have, interestingly, the perception was that African parties lose most of the time. But the recent statistics from the 50 years of investment state arbitration, yes, 50 years of exit arbitration on African states, 1974 to 2024. The statistics shows that actually Africa has won most of the time. 62% of cases involving African states have actually emerged more victorious. But that does not take away the perception that the system historically was skewed to favor foreign investors, given the origin of the system and the fact that it was an investor-driven system, and Africans were looking to embrace capital at the time, in the 60s and 70s when they began to sign the first generation BITs. So those are some of the concerns that have driven African states. And then if you look at the quantum of awards that have been awarded against African states, they are quite huge, in billions of dollars. I know it's not an investment case, but the P&ID case is a clear example of the sort of situation that drives African countries to begin to question the entire international arbitration framework, where you have over $11 billion awarded against a country in an arbitration that was ultimately found to be corrupt. All right. So all of these concerns are things that have fueled the Africanization of arbitration. Africans want to have more Africans appointed. We have not seen an African panel in ICSID of over 50 years in respect of any dispute. What do I mean by an African panel? An African panel dominated by 3 Africans. We have not seen it. Is it that we don't have the capacity? We do have the capacity. So these are the questions that we are talking about. Most of the appointments goes to Europeans, Western Europe particularly, all right? And what role will our institutions play? Very important, right? KIAC, NIAC, the Cairo Center, as they begin to administer arbitrations and begin to have government, support the arbitral process, then that will enhance their credibility. I see that under the investment protocol of the AFCIA, the African centers are going to play a very important role, because the idea is to keep African disputes within the African continent. And therefore, you're going to be saying that some of these disputes will have to go to African centers to be administered by African centers. Desai talked about a recent situation, which is unprecedented before until recently, where investment arbitrations are now beginning to be cited on the continent. So you're going to see the African institutions play a critical role in that regard in terms of administering investment dispute. That's not going to say that we'll push away the exit system completely. It will still be there. It will still be relevant. But African institutions will begin to take a more front burner role, right, in this process. And I hope, I sincerely hope that the African centers will rise up to the occasion in terms of capacity, in terms of infrastructure, and one thing we are beginning to see again on the continent, which will be of help, although in terms of domestic arbitration, is that there's a reform on African domestic laws, arbitration laws going on the continent, bringing it in line with international law, international best practice, and what you have at the international level. And what that can do for Africa is to ensure that, create the impression that it's arbitration friendly, then our courts increasingly are also beginning to support the arbitration process. We're beginning to see judgments come out from Kenya recently supporting the arbitration process, from Nigeria, from Uganda, from South Africa. So all of this shows that Africa is rising as a continent to the occasion. And hopefully we will see that increasingly our disputes are resolved here by Africans, by African institutions, by panels that are populated by Africans.
Thank you so much, Godwin. Nikhil, perhaps your thoughts. There are clear gaps in the seat of arbitration, the quantum of the claims against African nations, and the clear appointment of African arbitrators just not being there or being reserved for annulment proceedings or ancillary proceedings. In your view, how can we bridge these gaps, and how can we position ourselves through C.Arb, NCIA, KIAC to be a hub or to be a seat for some of these disputes, and position ourselves as arbitrators to be appointed for these positions, and also have people who look like us sitting on matters relating to us? What would your thoughts be?
Thanks, Wambui. I think one important thing, why do African states have, what is the main issue of these disputes being handled outside of Africa? And the main obvious and very relevant concern is that these are disputes which Godwin mentioned can go up to 11 billion US dollars, have a significant impact on our own national agendas, yet they're being decided outside of our continent and by arbitrators who are not aware of the nuances of our continent and no connection really with our continent, right? And that really is what is the main concern, I think, for African states. The extent of the award, the impact it could have on our countries, and the fact that we have no say in it, right? So while these agreements are being signed by us, we don't have a say in the actual dispute resolution. And whether we've actually, whether we're bridging that gap, I think definitely we are. I think if we're looking at just above 10 years from now, and we talk about international arbitration as a whole, I can talk about East Africa when I say that the East African continent itself has seen a number of arbitrators sitting on international arbitrations, right? We've had the growth of NCIA, KIAC. In Nigeria, we have formidable institutions. And all those institutions, what they do is they portray, I think, to the outside world and showcase our experience. It takes time for an institution to build a caseload, to build a credibility, but eventually we're getting there. Because there are investors who are foreign investors who are agreeing to use domestic institutions, rightly so, because they've been grounded on principles of international law, transparency, accountability, and the like. And as Godwin mentioned, a lot of our courts are issuing judgments and ruling which are pro-arbitration. So we're getting there, but it's not being reflected as much as we would definitely want to see it being reflected. Another point is that looking at the whole international arbitration scene as a whole, including investment arbitrations, you'll note that all of the institutions, be it ICSID, LCIA, ICC, have started having regional offices and bigger presences on the African continent. And that's for one reason. We are now accounting for a huge percentage of their work, which shows the impact that the African continent is having on the arbitration space. But more so than that, you'll also see, I definitely have seen it, in most of these international arbitrations, 10 years ago, you would have an international law firm being the primary counsel who are handling the arbitration. Now it's actually local law firms, and we are a good example of that with the cases that you mentioned you were involved in with your big win, Cortec Mining again. So all that eventually leads, hopefully, to the position whereby we will be in that position to be determining our own disputes. I think it's taken longer than it should, but we're definitely headed in the right direction. I think all the institutions have a massive role in pushing the agenda, which I think they are doing. So I think it looks promising in that regard. But the pressure obviously needs to keep on being applied, especially since we are accounting for a large portion of all these institutions' work.
Yeah, thank you for that. Perhaps delving into more practical questions of the processes and procedures of some of these investment arbitration proceedings. The corruption defense in investment arbitration, how sustainable is that, Nikhil? And we've seen that in multiple African cases. Why is that the leading defense advanced by us? And how viable is it or has it been?
Thank you. And that's quite a topical issue because we have seen it come up quite often. I won't delve too much into the Nigeria and PNID case, but I think for those who've not read the case, I'll just give you a brief summary of it. It was a claim that PNID, which is a company based out of the West that had against Nigeria with regard to a gas concession agreement. The arbitration proceedings were seated in London, and eventually PNID, which was the private investor, was awarded $11 billion. The Nigerian government then went to the courts in London, which was the seat of the arbitration, tried to overturn the gigantic award of 11 billion. And the grounds on which they sought to overturn it was that the contract, the underlying contract was procured by bribery, and the arbitral process was tainted by corruption. Now, this was all new evidence, so the English court agreed to hear the matter and to eventually overturn the matter. But what was interesting was to note that the bribery element with regard to the underlying contract came out later, but it came out, and Mr. Omoaka will correct me if I'm wrong, that is his area of expertise, but it came out after an external investigation by the corruption authorities in Nigeria that uncovered that an individual was actually paid to get the contract. And more interestingly, during the arbitral process, that individual was supplying confidential information to the other side and the lawyers of the other side, right? And that really eventually led to the award being turned around. Now, why we're seeing more and more of these matters is, honestly, some of the contracts that were in place previously may have actually been procured by bribery and corruption. And that's just the honest truth. We've seen it come out in different ways, not in arbitration, but in the court systems in our local jurisdictions. But we hadn't seen it coming up that much in investment arbitration. I think one of the first cases in investment arbitration was the World Duty Free case, which everyone's aware of, where corruption was alleged, and the case was actually dismissed on that basis. But really, the issues were: does a tribunal have jurisdiction to deal with corruption and bribery cases? Is that arbitrable? Another really relevant point is, how can a tribunal sitting outside get the relevant information or details regarding the corruption? Because it's a very high standard of proof, right? It's a criminal element, so it's quite a high standard of proof. So how would they do that? So jurisdictional elements, more practical considerations, meant that it wasn't considered as much. But then I think came a case called Metal Tech versus Uzbekistan, and that was a BIT claim, I believe, and it was in relation to a bribe given for the procurement of a contract, and the tribunal was and this was a defense being raised by the government of Uzbekistan, saying that their claim cannot stand because they bribed officials of our government at the time. So you can see the one side claiming their own wrongdoing being a defense. So that was another reason probably that we didn't see that as much before. But what happened in that case is that even though the government was in effect relying on its own individuals' being bribed to actually get into a contract, the tribunal agreed to determine to look at the matter and see if it has jurisdiction. It then decided to look at the evidence of the corruption. And because, as I said, they didn't have access to all the information, they used a criteria called clear and convincing evidence to prove corruption, right? And then they looked at what they termed as the red flags of corruption. And these were, in this case, it was, as we've heard a number of times, it was a consultancy agreement that was entered into by the private investor. And eventually the tribunal looked at what does the consultant do? Is he relevant to this contract? The answer was no. What are the consultant's professional qualifications? Are they relevant? The answer was no. What was the commission paid? The commission paid was 20% of the contract value. Again, a big red flag. And then obviously the existence of offshore accounts. And based on a number of those evidence, the tribunal found that the claim can't stand and it was dismissed, right? And so you're now seeing tribunals using that quite a lot, those red flag standards, and you're seeing governments relying on that defense quite a lot. They'll rely on it at the initial stages to say that, for example, in a BIT, we talked about most BITs stating that an investment is, any sort of investment in the host country made in accordance with the laws of the host country. So relying on that legality point, a number of governments have claimed that if a contract is procured by, or if an investment is made by bribery, it is not a legal investment in accordance with the BIT. If it's a contractual investment dispute, then the common defense is that the contract is void because it was based on illegality. So we're seeing more of those coming up. I do find it is going to be a sustainable defense, but there really does have to be a line drawn in the sand because, as I said, in effect, it is a state claiming a defense to an entire claim based on its own actions. So I don't think setting the right precedent going forward. Obviously, the tribunal has dealt with the element of the government's involvement in these bribery and corruption cases by awarding, telling them to pay their own costs, even though they win the claim. Or, for example, adjusting the damages computation to take into account the government's involvement. So those are there, but I think eventually it'll be hard for a defense of corruption on an entire claim being sustainable when that corruption really has been procured by one of the parties as well, or who's a party to it. So it'll be interesting to see how that's dealt with. But for now, I think it's open house for governments to use the defense.
Thanks so much, Nikhil, for that. Godwin, I'd love to get your perspective as well on the corruption defense. And are African nations double speaking? Are we on the one hand saying, we want a fair opportunity, we want a seat at the table, we want to people who better understand our circumstances, our traditions, our terrain to hear and determine matters on our behalf, and then on the other hand, turn around and always bring up the corruption defense as our main argument. Are we advancing ourselves? Is that detrimental to us? What are your thoughts?
Excellent question, Wambui. I don't think it is detrimental to us, and I think that is where I see it differently from Nikhil. The point is, corruption is an international public policy issue, right? You will understand why most of the Western world moved away from Africa in terms of doing a lot of investment. If you look at Africa right now, you see a lot of Chinese investors, South-South investors. That was the reason why they moved out. Some of them could not cope with the African way of doing business, right? And you know what that means. So you get a little kickback for something and other, and then they have legislations in their domestic countries that would penalize them if they were to offer bribes in a foreign country. So it was an important factor for them, something that they knew all along. Coming back to our continent, Africa, domestic laws also prohibit corruption, bribery, also local public policy. All right. The point is that I do think that it is legitimate for the African governments to run the corruption defense if and where they can find that there is evidence of corruption, compelling evidence of corruption, and which they can establish to the requisite standard, because the threshold is very, 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 very high. And that was exactly what played out in the P&ID case, where the government itself, a particular arm of government and certain ministers were involved in this corrupt scheme to build a gas processing plant, which was never built. And of course, the government itself, the government itself wasn't aware of it. So while it is true that a particular arm of government may be involved in the corruption, I don't think that that should be a basis for defeating a corruption defense if we can establish that indeed corruption has taken place in that case. So I think that African governments can run it. They are running it. Not only African governments are running it right now. After the Uzbekistan case, other countries are also running the corruption defense. So it's a veritable defense that you can run. Africa, unfortunately, as part of our developmental experience, is bogged down by these problems. We can't run away from it. And it's not a nice thing to say, but it is our reality, right? It is our reality. And that's why when you talk about Nigeria, when you talk about the World Duty case in Kenya, you hear this sort of conversation. But then it behoves investors who come onto the continent to invest not to exploit the circumstances, the situation. They say when you get to Rome, you behave like the Romans. If you cannot cope, you ship out. That's my view. So when you bribe your way through getting a contract, and once it is when eventually there's an arbitration, and the state is able to establish to the evidential threshold that is required, that indeed there has been a corruption, then by all means, African countries should run that defense. It's not the only defense they can run. I mean, we know that the FET standard is an amorphous standard that has, led to hugely contradictory jurisprudence on investment arbitration on the question of what is FET. Right, different tribunals speaking from different perspectives of what it is. Even the national treatment standard as well, also the same thing. Even the MFM standard. So the jurisprudence is not settled. And while I will say that the corruption defense is not the only defense, I think you will always put your strongest arm forward. Because with the other standards, as we know, the MFM standard, the national standard, they are like amoeba. They are very flexible. You can't really bank on those, right? But with corruption, you're very sure that once you can establish that, then it is unlikely that that claim will be sustained. And I think that was why Mr. Justice Knowles in the P&ID case, put an obligation on tribunals that where there's a corruption allegation, then you have to take certain steps, because most of these countries are developing countries. They need these resources for their development, right? And if the claims are so huge that it could potentially affect their GDP, then you have to be careful in the vast amounts that you award. So there's a huge obligation on tribunals today, whether in the commercial sphere or in the investment sphere of arbitration, to be very careful when they come to deal with claims where potentially there could be corruption cases, to ensure that the corruption defense is really, really run, and even to provide assistance to countries, right, who do not even have the capacity to run such a defense. For instance, it's part of the criticism of Mr. Justice Knowles of the very eminent tribunal in the P&ID case was that the tribunal failed in its responsibility to actually nudge Nigeria in the direction that it would have gone during the during the trial, ask the sort of questions it will have asked. Be more critical, be more open, criticize the process, ask questions, and they didn't do that. So I think that for African countries, and indeed any other country who wants to run the corrupt defense, the fact that the corruption was by an arm of government, in any case, it has to be by an arm of government, because it is an arm of government that will award the contract. But does that make it right? Does that make it a basis for defeating the defense? I don't think so. So I rather say that we will continue to run the defense, but I hope that it will not be something that we will have to contend with for too long, because it is not a sweet savour in the mouth. Thank you.
Thank you, Godwin. I think you touched on something that Nikhil spoke about, I think sometime earlier, I think in the introduction. And I'm curious, Nikhil, when we speak about like jurisdictional challenges and considerations, when we're arbitrating against states, what are your views on some of the jurisdictional challenges that are advanced by African states? In particular, looking at the Geka Mines case, particularly where your proceedings are against a state or a state corporation, and there is potential of the investor attaching some of any of the award against the assets of that corporation. Please give us your views on that.
Thanks. So I think on this point, really, I'd be talking more on the side of the investor, just based on my experience on claims we've had against state entities. And by and large, how we found the contracts panning out is that your contract, the private investor will be contracting with the state corporation, right, for the primary or the subject matter of the dispute. Right? The government may be involved in terms of giving a government support letter or providing a relevant license or something like that. But your main contractor would be the state corporation, right? And then you would have a separate letter from or an agreement with the government for whatever obligations they were doing. But two issues really arise here, in my view. One is that, say you have an arbitration agreement with the state corporation for an arbitration at ICSID or the LCIA, but you don't have a similar arbitration agreement in the contract with the actual government. There's a problem that comes up in terms of how do you bring the government as a party to those arbitration proceedings. And the problem exists, it could exist because your main claim is against the government, so you want the government to be a part of the arbitration. But more often than not, it's because you want the government to be a party and liable, if you can make the connection, so that you're able to enforce an eventual arbitral award against the government's assets, as opposed to the state corporation, which will probably not have as much assets outside of the jurisdiction, right? Now, there are two ways really we've looked in going around that. One is trying to get the government or the state entity as part of the arbitration agreement through the group of doctrines concept. And I think the leading case on that is the Fiona Trust case in the UK, which says that you need to look at the entire transaction as a whole and the arbitration agreement and what the parties' intentions were. So if the two contracts are so closely connected that the parties would have intended that any dispute with the state corporation should also include the government, then on the basis that common law is applicable, the group of doctrine companies would apply. But the Geka Means principle is something we've seen come up in two respects. One is to bring a party to an arbitration proceedings or government to an arbitration proceedings, but two, also at the enforcement stage. So in terms of using Geka Means to bring a party to an arbitration, the Geka Means case basically says that if you are transacting with a state corporation, which is one and the same as the government, then you're able to bring in the government to the arbitration proceedings. Now, it's never been successfully used in that regard, but there have been a number of attempts. Now, what the tribunal will look at is how closely connected are the state corporation and the government. They look at control of the board of directors of the state corporation. How are they appointed? Who controls the budget? Who approves the executive notices and policies of the state corporation? So there are there's a list of around 15 things that tribunal will look at to see whether the state corporation and the government are one and the same entity. Conversely, if you have an eventual arbitral award against a state corporation, and you'll find that the state corporations don't have assets outside of the host country, you're then stuck with who do you enforce against? Now, at that point, again, you can try and rely on GECA means to say that the state corporation was one and the same as the government, and therefore the government's commercial assets outside of the jurisdiction should be open for enforcement. So that's one of the interesting things I've seen. Obviously, there are the obvious things of governments claiming state acts or immunity from prosecution or immunity from execution. But this is something I think, and if we're acting in arbitration, whereby one of the states has in settlement discussions have said, well, you can go ahead with this arbitration, but you're going to have problems with enforcement because we've now set ourselves up in such a way that will be impossible for you. So, and one of the ways is this, setting up your main contracts with a separate entity which doesn't have assets in which you can enforce against. So I think that's something that's coming up more and more.
Thanks so much, Nikhil. And I see we have Professor Mutuma back with us. Hopefully, Professor, you can hear us, your audio is okay, and your camera is okay. Perhaps I can ask you the next question. And I think what we want to delve into is third-party funding in investment arbitration. It has been used to a certain degree as a double-edged sword towards African nations. What are your thoughts?
All right. Sorry, the time I got disconnected, I was trying to make a very important point. Maybe with your kind permission, Madam Moderator, I can make it. It ties to everything that we're discussing. The point has to do with how this entire area has been influenced by generally what corporations and what investments should look like. So before, there was a very strong taint and inclination towards the financial aspects. But as you can see, the entire world of business has been redefined. So what is good for business is not just the financial aspect. There are many other non-financial aspects that have come up, including in the language of corporate social responsibility, and more recently in the language of ESG and so forth. So that has turned the discussion around disputes, whether it's the bilateral investment treaty disputes, or whether it's your international commercial arbitration investment-based disputes, it's turned the language to start asking how those disputes are resolved and the extent that they bring in this greater picture of the corporation as a responsible citizen in the planet, so in the environment, questions about labor rights and so forth, questions around society, community, public participation and things of that nature. And that, of course, then has, the time that I dropped off, redefined the weighting of dispute resolution clauses and what the expectation. So it's brought in certain precursors in terms of what the agreements look like, what the process looks like, and what the outcome should actually look like, including the hefty nature of the awards that in many cases will be paid by the public. The other area, of course, the nuance that is here hiding behind the scenes is the political tensions right from the post-Second World War world which is very Western, very Western-centric, Eurocentric, and other players that then got onto the scene, including many African countries that come in, and how that has to be revisited in terms of the power dynamic and creating an equal playing field. Because disputes are really about that. It's people feeling that I am in a place where there's equality. So that ties quite closely with the question of third-party funding. Because third-party financing is really about a claimant or in some instances a respondent who doesn't have what it takes in financial muscle to address their claim or their defense, and more importantly, that it's a very strong claim, which of course brings the financier into the picture, because ordinarily nothing is really being done for free. So the major question is what does that mean in terms of all of these issues that we are discussing when that financier comes in? What does it mean when it comes to the control of the process, the proceedings? What does it mean when it comes to the outcome, when it comes to questions around confidentiality, when it comes to even the ethics and then the ethical side of who is really controlling this between council and where council is receiving their instructions from. What does it mean? And I think this really gets really untidy when you now bring in governments there, and governments operate with a very interesting paradigm when it comes to public finance and ownership of processes, because governments are public entities, and now you have brought in a private entity into this entire mix. So those are some of the tensions, of course, that start to pop up. We haven't seen in Africa yet the kind of third-party funding arrangements that are in the Middle East, Dubai, and London. Not as yet. I guess that's because this specific area requires a highly advanced and economy where the subject matters that you're dealing with in the disputes are colossal to attract this financer. But I believe we will start to see that as we move more and more into that arena. I believe also the insurance industry at a local perspective has started thinking about these issues, and not necessarily for big claims, but also for a much smaller claim, how to bring an appendage or an addendum of disputes and the outcome of those disputes that will handle all of that. So allow me to stop there and give my esteemed colleagues a chance to weigh in on the discussion. Thank you.
Thank you so much, Professor Mtuma. I think, Godwin, I'd just love to get your thoughts on the question of third-party funding in investment arbitration. Are there enough safeguards on transparency and who's behind the veil? Is it something that should continue to be utilized? And how are we seeing it in particular regard to African nations and the arbitrations that they are involved in?
Thank you, Madam Moderator. Third-party funding is a very important issue. And I think for African states, one of the major concerns is that the ISDS framework as presently constituted is heavily skewed in favor of the investor. And with third-party funding, it becomes even, permit me to use the word, more skewer, right? Because what you find is that for poor African states that are struggling to develop, if a funder were to fund an investor, then it could potentially lead to claims being brought against Africans, even speculative claims. The P&ID case, while again not an investment arbitration case, is a clear example where perhaps third-party funding was at play. If you recall, part of the finding of the judge, Mr. Justice No, was that the barristers for P&ID were to earn as much as £3 million, 3 million or 3 billion pounds from the award itself, right? Which sort of lent credence to the fact that there was some hidden, some non-disclosed arrangement between P&ID and its barristers in terms of the funding of that arbitration, which led to potential conflict of interest. Okay, so it's very important that at the end of the day, there's transparency. African countries are also going to be pushing for security for cost, because again, when you have TPI-backed investors, they should be required to post security for cost for frivolous claims. You know, tribunals are split; some will reject it, some will not. Some will accept it, because at the end of the day, where the African state prevails, then it is most times not able to recover some of its costs. But again, I think the fundamental issue is the public policy concerns involved. Third-party funding clearly encourages speculative and opportunistic claims, in my view, against African states, especially in the extractive sector, where you get funders, because funders, what are they doing? They're looking for money. They're looking for money. So they're ready to fund a litigation or an arbitration, you know, as long as they are certain that there is some possibility of them recovering their money from the award. Don't forget, it's a no recourse funding, which simply means that if they lose, that's the end of it. They don't get anything back. But if they win, then they recover, and so they can begin to press and encourage investors to actually push claims that are not very credible against African states. As we have seen it with Nigeria, I think because of the public policy consideration, the public interest issues that afflict most African states, it is important that there are disclosure with third-party funders. Very, very important that there are disclosures, because that way the states are able to know what they are dealing with and whether there are potential conflicts and who these funders are and how much is being put into the process. I think under the exceed rules, it allows for disclosure of third party. It makes room for provision for disclosure of third party funding. I think it's very important. We're also beginning to see that Nigeria, for instance, has passed the new Arbitration and Mediation Act, which allows for disclosure of third party funding in every sort of arbitration. And that will, in my view, include both international commercial arbitration and investment arbitration. Of course, there are the Austria rules on transparency of 2014, which encourages disclosure of funding arrangements and all of that. So with all of these things, I think the basic thing is that there should be disclosure. There should be protection of, there should be prevention of conflict of interest, so that the African states understand what they are dealing with, who the funders are, and if there's the possibility for them to object to the funders, then they are able to do so. Because part of the challenge in the P&ID case is that we didn't know to understand the funding arrangement. But clearly, there was an implication that if a barrister was going to get 3 billion, right, of the award, then of course, like Mr. Justice Knows rightly found, that potentially suggests that there must be some arrangement that could show that the lawyer was putting funds into the arbitration. So for me, those would be my take, that there is disclosure. There are already clear regulatory framework in the international system. The exit rules 2022 amended rules provide for that. The Official Rules on Transparency provide for that. The new generation BITs, even though do not, in some cases, expressly provide for that, do lay stronger emphasis on transparency and responsible conduct. All right. And that, again, is an important point to take into consideration, in my view. I'll hand it over to you, Wambui.
Yes, Madam Moderator, if I could come in on that, because my good friend Godwin has actually hit the nail on the head. You see, this the big elephant in the room is the world of arbitration has always operated in under two legs. This question of confidentiality of proceedings, and there's a reason for that. Of course, it was meant to be an advantage. But the arena, and I'm glad that we're discussing this wonderful case, PNID versus Nigeria, the arena in which all of this now can turn bad, because you have, as it were, confidentiality as a shield. Nothing demonstrates that more. The other, of course, is the fostering of private investments was always seen as a contractual issue. It was always about what the parties have agreed. And now we're in the world of international commercial arbitration. But more and more, like some of the factors that he raised, a lot of countries and societies have woken up to public consciousness and how it manifests when it comes to redefining public policy and redefining public interest. And what you can get away with in the past is certainly not the experience now. I was just looking at the stats on that specific case. And if that decision had not been overturned by Justice Knowles, you would have been looking at Nigeria losing nearly 1/3 of its foreign currency reserves. So this, what everyone now is saying is this can't simply be a question of your private party contractual arrangements. And the outcome certainly can't be that. And Africa is the one that has been reeling on a lot of these awards and what they look like when they come out of the pipeline. So I wanted to say that, as always, Godwin always provokes, says a few things and provokes our thoughts in a particular direction. He's the master of this debate and what is happening in the public arena. Back to you, Madam Moderator.
No, thank you, Professor Mutuma. I think I was just going to echo what you're saying. There's been so much debate as to the extent that the investment arbitration proceedings involve state parties. The public has a right to know what is going on, and that right far outweighs that of confidentiality, which is basically the foundation of arbitral proceedings. So, Godwin, you have my vote. I'm aligned with you, I must say. But I think that's all the time we have for today. We do have a couple of questions from our audience, and perhaps I can just read them out to each panel.
Network. Wine, have we lost Wambui, or is it my network?
I think we have, because I can see both you and Nikhil quite well. But maybe before she even asked the questions, I was going to ask Nikhil something around the trends, because I was in the Hague the other day.
Yeah,
I could see there is a very strong. This area, there is a bit of jostling. ICC has been the leading force when it comes to our region and international commercial arbitration. But I can see, I don't know what your thoughts are on the geopolitical situation. Russia, what's happening with US trade wars, the mistrust of certain areas, including seats, certain arbitrators of particular nationality, and even to say the least, maybe even certain organizations, because of their history, maybe their history being very strong in the Western area. What kind of thoughts have you been getting? I'm saying this because I saw the PCA has been trying to get into an area that is very predominant. It has predominantly been in the hands of the ICC. Any thoughts around that? Nikhil, you're muted. I suspect you're muted. Yeah.
Sorry, you're referring to the handling of the disputes in those areas?
Yes, correct, yes.
Yeah, so, literally in the US and Ukraine and Russia, I see I've been having the highest number of institutional cases historically. But I think given the recent judgments that were enforced in France, well, not recent, a couple of years ago, in France against the Russian entities and some four, I think there's been a bit of backlash on whether these states actually now have, full faith in some institutions. So the institutions are being dragged into this geopolitical situation we're seeing. But I don't think it has anything to do with the institution. As you know, institutions are largely administering entities. It's just the name of the awards that come out of it that drag people in there. Yeah.
Yeah. I thought that point had not come out, but our moderator is back. Moderator, I don't know whether it's appropriate to say we were holding your brief collectively.
Thank you. I'm most grateful. I don't know why my connection dropped off. Sorry about that. I don't know if you had my question, Nikhil.
No, I didn't. Sorry.
Unfortunately, I'd probably have to ask Evelyn to read out the questions in the comments because now I don't have sight of them, unfortunately. Evelyn, would you be kind?
All right, not a problem. So there is a question from Joseph Muigai. He's asking, kindly weigh in on how AFCFTA protocol seeks to terminate all intra-Africa BITs through a single rule book, but externally African countries still maintain the old generation BITs with non-African states. Doesn't this weaken our pursuit of African sovereignty in investment realm?
Godwin, do you want to take the Africa continental since you're dealing with that?
Yes. Now, my view of that is that the protocol really thinks, so it provides a 5-year time frame for the expiration of every intra-African BIT. And of course, unlike what you will have in a typical BIT where you have a sunset clause that allows for claims to be brought even after the expiration of the BIT or the termination of the BIT for at least a 20-year period. What the protocol seeks to do is to say that, look, once the intra-African BITs are expired after a 5-year period, then you cannot bring any claims under those first-generation BITs, all right? And for me, that makes sense. Otherwise, what you are going to find is what we have in the current system, whereby even after the expiration of the BITs, people will continue to bring claims. A good example is the ECT, the Energy Charter Treaty, right? Which, I mean, a lot of countries have literally opted out for, but people can still bring claims under it because it has a 20-year sunset period or that sort of thing. So I think that the investment protocol of the AFCTA, it's something that is forward-looking. It seeks to protect African states from claims, in relation to first BIT claims. The question is whether, in relation to those intra-African BITs, whether having signed up to the African investment and the new investment protocol of the AFCTA, states will be able to have effectively waived their right or ceded their right to pursue claims under the first generation intra-African BITs. My view is that they will have done so, but will that extend to claims under the exit framework? I doubt so. I think you will still be able to bring claims under the exit framework, regardless of what the investment protocol under the FCTA say. That's my view.
Yeah, I agree. I think that the non-African state BITs would obviously have to follow the procedure as per the BITs for termination and the sunset clause. But the real, I think I'm just reading the question, is whether it weakens the position that these non-African BITs are still in place. I think that's what we were trying to address earlier. It's not something that will be able to happen overnight. But indeed, what we're pushing for, and all these protocols, including the AFCATA, the SADC protocols, they're all pushing for remodeling of the international BITs. So it's really up to the states to be up to date with those relevant provisions in the model BITs and ensure that the new generation BITs that they enter into are have the relevant provisions which we talked about earlier today.
And I think the most difficult part about it is, and that's what the CFTA is really trying to do, is how you get the entire continent to match in rank. I think that's the most difficult thing. So of course, all of this is about bargaining positions and your counterparts on the other side. We are catching up way after the world of dispute resolution has been strongly developed in the North. And how do you do that? And you certainly don't do it the way we've tried in the past, through individual countries getting into bilateral treaties. The power dynamic just doesn't support that. So the CFTA, to the extent that it's trying to shepherd all of this together, and the protocol and the relevant annexure, trying to get us onto the quote-unquote global scene as a consolidated unit, has to be applauded. But Africa has many other political problems, whether we will hold ranks. You can see even here we've come under a lot of criticism because of our BITs with the UK and so forth. So I suspect we will solve that dynamic somehow.
All right, thank you. And also maybe I can also add, based on some comments I'd put on the chat function, in a solution towards, creating some sense of coherence or harmonization of these African BITs as part of the solution. Africa Arbitration Academy in 2022 came up with model BITs for African states. And this is in line with what Nikhil was saying, and I've put the PDF version of those model BIT rules. And I think if you're to look at them, you'll be able to appreciate what they represent for the African states, since essentially they are solving the current problems that we have identified with the first generation of the BITs. So I just wanted to highlight that in line with that question. There's another question from Collins Konge. He has said that from this rich discussion, we are convinced that arbitrators under BITs and ICSID so often sit outside Africa, even though much of the investments flows are from here. So beyond a system historically skewed to favor advanced economies, isn't it also the political instability and governance challenges within Africa that stifle our progress and prevent the continent from becoming a credible seat of arbitration?
That is a favorite from my end. I know both Godwin and Nikhil will step in. I think a lot of us are really, really tired about this perception. I think everything is always thrown back to a historical lens that's shaded in, it has these shades of us lacking capacity, being in war-torn countries, having judiciaries that cannot be trusted, and so forth. And that perception of the absence of capacity that is on the African continent. I mean, we've been speaking capacity for such a long time. You can see, Godwin, I hope you'll weigh in on this. But I'm not sure when that conversation actually ends. But the result is this terrible inequality where in one conference which we attended in Kigali, believe it or not, there was a gentleman from the north, and we had a side conversation. I think he had about quite a number of arbitrations that he was doing. They were all in Africa, and 90% of them were being handled by colleagues from the north. He literally, and he, of course, he didn't know he was speaking about that conversation in a sense of pride. But me, who was the recipient, was thinking, oh my, this is really terrible. You've got an African dispute. You have a seat that is somewhere in Paris, London, and we know the usual culprits. And you also have it being administered in a venue somewhere in the north, and also with our counterparts from the north. I think that is not a capacity problem. I certainly do not see it as a capacity problem. I see it as, even when you think about reciprocity, if you think about how many Africans are handling disputes that are happening in the north, if you just, play around with probabilities, toss the coin, you would expect at least a few Africans to be handling predominantly disputes natured in Europe, somewhere in a seat in Africa, and with an African panel. But that doesn't translate. So my thoughts in this are that probably one of the areas that we have failed is in the kind of cross-border collaboration we have amongst the practitioners in this area. I think the North has done that very well, including the London Court of the LCIA has done that. That's really practitioners putting together something. Second, I think in terms of harmonization and legal structures, questions around enforcement, Africa has that division that sits with it, either in terms of language, Anglophone, Lusophone, Francophone, and all of that. Rwanda has tried to do what they do, but mainly in Francophone related zones. We need to expedite that. I think technology today also allows us to do much more than we could yesterday, because technology creates virtual spaces and platforms, which if someone points at logistical difficulties or costs, that can be addressed through technology. And then last but not least, I think we've got a lot to do as practitioners in telling our own narrative, making sure, like we're having a big conference that's coming up, making sure that somehow we get Godwin and quite a number of serious resources onto that conference to be our key speakers, get Nikhil to speak, to start to showcase both in terms of visibility, what we have, but and last but not least, which is my area of interest, to write about what we speak and not have everyone else writing and we're really mute on the subject. So we've got a lot to write, and writing up, unfortunately, is always taken as the ultimate authority of whether you know a subject or you don't. Thank you, Madam CEO. I can see our moderator is back. Thank you.
Thank you, Wayne, for those comments. If I may chime in here, and this is an area that I'm very passionate about because it's all about psychological brainwashing. You know, when we begin to think that we are made to believe we are not good enough, and we begin to swallow it, it's all balderdash. We have some of the best brains you can find on planet Earth, in any field of human endeavor. All right. So the question of capacity has been used as a weapon that has been weaponized against Africans in the appointment process. I'll tell you something interesting. In the 2025 statistics, ICSID have appointed 6 Nigerians. They call them Nigerian UK citizens, whether Nigerians with UK origin or whatever, but bottom line is that they are Nigerians, right? And both within the continent and in the diaspora, we have capacity in abundance. Arbitration, I have always said, and a lot of people have not liked me for this, is a cartel. If you go back to the investment arbitration treaty back in 1964, when the system started with the World Bank, Aaron Brushes, the general counsel of the World Bank at the time, talked about investment flowing into Africa. And the whole idea was to protect the investor. The ISDS system was set up to protect the investor as an arm of the World Bank. That is what it is. African states were at the time emerging from independence, from colonialism. They were looking to develop. They didn't have capital. So they were taking these bitter abortion pills that were being swallowed, that they were being given, in the form of first generation BITs. These BITs were not drafted by Africans. Read the history. The Africans walked into a room somewhere in Europe, in Washington, sat down, the BITs were put on the table, you want capital, sign this, and they signed. That was what exactly happened. Fast forward 20, 25, 30 years down the line, they are becoming victims of documents that they signed. If it was today, we would plead non est factum. Right? But they signed these documents. So the truth of the matter is that the whole idea from the conception of the investor state system, the setup of the ICSID, was to protect the investment of the investor in foreign currency, because all they wanted was full repatriation of profits and dividend. That was the whole idea. So let's not be deceived with this idea that we are not competent. No. And if a foreign investor has a dispute with an African state, ask me, which law firm will he go to? Of course, the one he knows, the one seated in Brussels, in Paris, in London, in New York. They will walk into them. These are the guys who draft the agreements. These are the lawyers they know. Those guys will come into Kenya and Nigeria and look for a local law firm and partner with them to advise them on Nigerian law while they run the show. So it's a system that has been devised to keep capital where they believe it belongs, which is in the West, and to pauperize us. So we need to push back. And I think my brother Wayne has put it, and I can't put it better than the way he has put it. We need to talk about it. We need to write about it, more importantly, write about it, so that people begin to see that this is a charade. It's the same thing that is applicable in the commercial arbitration sphere. So let's not be deceived that Africa have no capacity. It's insulting us when you say we do not have capacity. You are insulting us. And we're not going to take that insult. Enough is enough. We have the capacity. There was an arbitration, investment arbitration that was done a few years, was it last year? I think there was a traffic light arbitration by Ghana, by the Ministry of Justice. All the lawyers for the Ministry of Justice in Ghana. It was an exit arbitration and the one. Kenya has set the pace on that as well. So we should stop hearing this, oh, they don't have the capacity, their system is not developed. It's all bullshit. It's all meant to keep capital where they think it rightfully belongs. But trust me, that capital is going to come back home sooner rather than later. Like Nikhil said, it's a process. It will take us a while to get there. But we will continue to push hard, and we'll definitely get to that destination someday. Thank you, gentlemen and ladies.
Thank you so much, Godwin. We have one final question, and perhaps Nikhil can take this one. Collins again asks, there are sovereign governments entering into treaties primarily to access funds for misappropriation, only for subsequent regimes to disown or disregard these commitments, thereby fueling recurrent conflicts with investors. How can the dispute resolution actors point out recommendations that inspire confidence with this being a central concern?
Thank you. So I think the question is, international treaties entered into with the sole intention to misappropriate funds. Is that correct?
Yep.
Yeah, I mean, obviously, I think if that's the case, there are mechanisms under these treaties to actually deal with, as between two host states, with the provisions in those treaties and how each state is implementing those treaties. So I would say that it would be a claim made against the other state for setting aside the treaty on whatever grounds are considered relevant, because the BITs have provision for investor state arbitration, but they also have a provision for dealing with issues arising as between the host states. So that would be my suggestion.
Thanks, Nikhil, for that. I think a final question, and I think it's I who's most curious about it. I was wondering, we have had discussions about how we can get arbitrators from Africa to sit on some of these proceedings. We've spoken about how our institutions can be best crafted to be the seats of these proceedings. We've spoken about how African councils are well equipped already to act on these proceedings. But I think what I'm most curious about is when we look at the BITs, moving away from the old BITs into renegotiated BITs, how can Africa have more of a say than it did before in these negotiations, in these agreements, or the reframing of some of these agreements in view of the current geopolitical climate? We do have the resource, yes, but I still think that we haven't moved entirely away from the circumstances that were prevailing initially. So how does that affect some of the agreements that we are trying to craft today and getting some of these investors to the table to agree to fair agreements? And that's the question I had actually asked Professor Mutuma earlier. So your thoughts on that would be most welcome.
I think I would say that Africa is only as good as its ability to master the collective wishes and interests of the continent. And that has always been our albatross, that we face investors as individual countries. And our regional integration aspiration, our Pan-African aspiration of our predecessors just doesn't quite get there. I've been thinking about this question quite a lot, and I've decided that part of the answer might lie in what we do as practitioners in the private space, the kind of collaborations that we build, and the way those collaborations influence this uneven playing field. So I don't think we should not forever remain at the behest of the public authorities, government, and the their speed or rate towards bringing us all together to speak one language when we're facing the investor. So there are a lot of developments in that private space, similar to what has been happening in other professions, where African arbitrators and dispute resolvers are trying to come up with formations. I think you are aware of the Africa Arbitration Association and what's been happening in that area. It started and it's moving steadily towards the end, towards this aspiration. I think those spaces will also enable us to make a loud echoes in policy, because then we are speaking not just as individuals. So for me, I think the answer is really the synergy that we develop in the private space, because I don't want to leave everything to governments, and governments haven't always seen the use of doing certain things. We have that difficulty. I have also seen things happening in the space of judicial authority. I know our Chief Justice, who is our patron, has been pushing indirectly through a platform with other CJs on how we can redefine the rules of engagement in this area. So I think the potential also of the courts to make pronouncements and to influence the DNA in this world is quite huge. So that's where I believe. But I know I was going to ask my friend who's done much more than I have with the LCIA, how we can re-engineer. The London has swum in the advantage of the common law system. So it has literally made dispute resolution a service, sometimes as a service that it exports. Because by default, you tend to think whenever you have anything that of an agreement with an English system, that let me get people from England. So I don't know, maybe he would have some thoughts in this area. Godwin, I know Nikhil maybe engaging with Paris might also have some thoughts, but I'm very curious to also learn from them. Thank you.
Godwin, would you like to give us your views?
Okay, I think Wayne has really hit the nail on the head. One thing we see right now is that African countries are not in 1964. They are in 2025, 2000 and so forth. And what do I mean by that? We can see the gradual reform movement in the BIT process taking place. Evelyn talked about the African Academy BIT, the Nigerian model BIT. A few other African countries have come up with their own BITs. What does that signify? That signposts that, unlike in 1964 and in the 70s, when BITs were put on the table for them to sign, now they are coming with their own model BITs and saying, look, if you want to invest in Africa, if you want to do business with us, these are the terms on which we will do business with you. And why are they doing so? Because African governments, while they require foreign investment, have gotten to a level of maturity as well, where they know that, like the beautiful bride, they had been courted by various countries and various nations who want to pour money in their economy. So we talked about, Nikhil talked about the South-South investment, which is very, very important in this case. It's no longer a North-South investment. Right now, you're seeing investment, two African countries doing business, finding BITs, an African country and an Arab country, and a country from South America signing BITs. So this is happening. They have more options. So it's important. And how are government doing this? They are beginning to listen to our voice. Those of us who are in the private practice space, we are beginning to influence government in more ways than we have done before. Our voice has been listened to. Key individuals who are probably part of our arbitration community get appointment into government as AG, as permanent solicitors, and then they are liaising with their colleagues in the arbitration community to ensure that these things are happening. And a lot of the criticisms about the ISDS system in the first generation BITs are clearly understood by African governments right now, and therefore they have developed their own alternatives to those BITs. So I don't think that African governments are in a weak as much position as they were before. I do not deny that we have issues. We do have issues of corruption. We do have issues of misgovernance, but that does not mean that we are not able to sit on the table and negotiate from a stronger position. I think that's what we are doing at the moment. We are negotiating on a stronger position. We are no longer signing BITs that they have written, the US model BIT, the Canada model BIT, the UK model BIT. We are no longer signing those. We are now pushing to sign the BIT that we have written. And I think we should be commended for that. And I think they are going to be signing it. If they don't sign it, then of course we'll move somewhere else. I give you a good example. There has been a lot of divestment in the Nigerian oil and gas industry by the Western countries. But what has happened? People thought that there'll be a vacuum. But what we have seen capital flow in from India. We've seen capital flow in from Singapore. We've seen capital flow in from other countries. We have even seen African businesses coming together to form a consortium to invest and to take up those opportunities. So Africa is the continent that feeds the world. More than 70% of the world's natural resources are on this continent. They will always come. They will look for a way to come. But we must be ready with our capacity, with our documents, to dictate the terms on which we want to enter into any union with them. Thank you.
Thanks. I think so. I'll keep it at a minute, but I agree fully with Godwin and Chairman. I think the information is out there. It's about the government sitting down with a stronger position. And look, everyone criticized South Africa for a number of years as to its actions, which they called harsh. South Africa is still doing very well, attracting the investment it wants based on its own policies. And the reason was, at that time, South Africa was working on a strong position and they stuck to their guns. So it's not a definite that you have to sign a new model BIT. I think it depends on each African state's negotiating position at the time and grab the best outcome for yourself. But definitely the knowledge is out there. Everyone is talking about this new model BITs, and the statistics show that in the last 5 years there have not been, or there are very few old generation BITs. The ones we are seeing are the intra-Africa BITs coming in place. So I do think there's a positive movement there. And then just on how do we ensure that we get a seat in the arbitrations, both investment and commercial? I agree with both my co-panelists that it's about us pushing the agenda, because while the foreigner will have their foreign counsel, it's starting to be that the person from our side is also a local lawyer who can advise on the arbitral institutions, the seat of the particular country. So it really rests on us. A lot of us sit on, chairman sits as chairman of C.Arb. Some sit in the ICC. It's our duty to actually push African nominations forward. And I think that's how we'll get somewhere.
Thank you so much, Nikhil. I think we can go on and on and on about this topic. It's quite engaging and riveting. but due to time constraints, I have to thank our panelists, Godwin, Nikhil, and Professor Mutuma. I'm so grateful for the opportunity and the discussion. I would like to hand over to our sponsors, both C.Arb, MKU, and the South Africa Institute of Excellence. They do have some good things lined up for us in the coming weeks. So I kindly hand over to Evelyn, who will introduce them. And I thank you once again for your time and for those on the platform. Thank you.
Yeah. Thank you, Wambui, for excellent moderation and to our panelists for excellent discussion. I was feeling it. We could have gone on and on and on and on. It was a very, very interesting conversation. As I mentioned when we were starting, that this event has been brought to you in partnership with Institute of International and Development Law, that is Directorate at MKU, as well as the International Law Institute, South African Center for Excellence, coming from an MOU that we signed earlier in the year. And we have these two organizations represented today. So I'd like to just do a few seconds or a few minutes to Judy Gayo, who's the director of IDLO, just to mention a few words, and then to Brenda, representative of INI Sachi. Judy, you're welcome.
Thank you so much. I don't know if you can see me. I hope you can and hear me.
Yes, we can hear you.
Okay, thank you. And as you've heard, my name is Judy Ngayo. I'm the director for the Institute of International and Development Law at Mount Kenya University School of Law. And I really just want to thank you, C.Arb, for organizing this, for the partnership. This is the reason that we entered into a partnership with South Africa Center of Excellence and yourselves to have these engagements, these legal debates in the field of investment arbitration, and particularly in ICSID. As we've heard from our wonderful panelists, Africa is facing great real challenges: the high cost of proceedings, the underrepresentation of African arbitrators, etc., the perceptions of investor bias, etc. And this is a time where we need some action, and action would come through research, through training and partnerships. And this is one of the reasons we entered into this partnership, so that we can also bridge the gap between academia and the practice, and give confidence to African lawyers, policymakers and arbitrators, so that Africa can help shape the future of dispute resolution rather than just merely responding to it. I know that we are really out of time. I had hoped that I could speak a little bit more, but I understand, and it was such a wonderful engagement. I really want to take this chance just to thank our panelists. You were amazing, and it was very engaging, and we all were captivated by the whole webinar. So I thank you all for those who are here with us, and we hope that you will share this recording, because I think many more will benefit from this. Thank you very much.
Thank you, Judy. Let's hear from Brenda.
Okay, I hope you can all see and hear me. Thank you, Evelyn.
Yes, we can.
Fantastic. So my name is Brenda Mudari, as you've heard. I am the Legal and Public Affairs Officer at the South Africa Center for Excellence, as well as an associate at the Chartered Institute of Arbitrators. Now, on behalf of ILI, South Africa Center of Excellence, I'd like to first and foremost thank you for joining us in this important discussion. We at ILI SACE, our mission has always been to build legal and governance capacity across Africa with a strong focus on rule of law. And our belief has always been that creating trusted and credible dispute resolution frameworks are fundamental to creating an environment where investment and development can, thrive. And for us, arbitration, in particular investment arbitration, is an area of deep interest. And with this regard, we have partnerships with ICSID, central and regional arbitration centers all over the world to support training, dialogue, and knowledge exchange. Judy has mentioned how integral it is that knowledge exchange is in terms of building capacity for Africa and building the Africa that we want. And our programs on public-private partnership frameworks, energy projects, and international commercial law also provide platforms for addressing this investor-state disputes and strengthening Africa's voice in the evolving arbitration landscape. And so for today's session, we are particularly delighted at the fact that it has underscored both the progress that has been made and the challenges that remain, as has been mentioned over and over in the duration of this call. And we are grateful to the distinguished speakers, Professor Wyne, Mr. Desai, Mr. Omoaka, and to our able moderator, Ms. Muigai. Thank you so much to all of you for sharing your perspectives. And we sincerely thank our partners, C.Arb Kenya and IID FIDLAW, MKU, for collaborating with us in convening this timely discussion. And finally, to all the participants, we appreciate your engagement. At ILI SACE, we look forward to continuing partnerships that enhance Africa's arbitration capacity, strengthen institution, and advance the rule of law across our continent. And we look forward to having all of you in a program that we are having, a 3-day investment arbitration program that we'll be having in partnership with 3 partners currently on this call, including ICSID as well, which will be the 4th partner, in delivering a 3-day training program from September 25th to September 29th. And we look forward to welcoming you all to that session. Thank you so much.
Thank you, Brenda, for that, highlighting the role that LI SACE is doing, and now also highlighting what is coming up regarding that particular training. And from the discussions we've had from our panelists, I think it becomes very critical that we continue building the capacity of arbitrators in this specific sector. So this training highlights that, and we're very, very lucky that ICSID will be coming in to train on that particular issue. So just to add on to what Brenda has said, the training that we have planned is in 2 phases. So the first one is going to be virtual, that is on the 25th to the 29th of September. And then the second leg of that training will be a 5-day in-person training, a very intense but very rich training program that is going to be held here in Nairobi. And we're targeting practitioners from across Africa for that investments arbitration training. So we'll be sharing the details of both trainings with you. So look out for that if it's something that interests you. We've been told that disputes are coming to Africa, investments trends are on the rise. So it's very important that we are prepared and we have the requisite skills to manage them and to handle them when they come. I'd also want to highlight that we are continuing our journey, or at least our planning of the ADR week, just as Chairman had highlighted earlier. The ADR week is going to be on the 17th to the 21st of November. I know most of you may have gotten those emails highlighting on what the event is all about. But additionally, I've also put on the chat the program, the working draft of the program, just so that you see what it is that we have in store. We are looking at having a stakeholder engagement heavy program where we're bringing all the sectors in a dispute resolution ecosystem at the table to discuss critical issues affecting them, with an aim of creating solutions, continuing conversation, but also enhancing access to justice through arbitration and ADR. So please look out for that information. Register. We've tried as much as possible to reduce the cost for you as our members as well as our partners. We've made those considerations considering the current climate of economic times. So we've curated a very, very good program. We've made it very affordable. It's going to be at the Kenya School of Government. So we have sufficient space for you. We're targeting about 500 delegates. So you can imagine it's going to be a really, really enriching experience. And we hope to see you there. Thank you so much for your time. Thank you so much for being with us. and we look forward to engaging you in the next event. Wambui?
No, I just wanted to echo your sentiments, Evelyn. Thank you so much. Thank you and to everyone on our platform for making the time. Thank you to our esteemed panelists, and just thank you to the entire team, our sponsors and the organizers. Do have a pleasant afternoon. Bye.
Bye-bye.
Right.